Hello, you're watching Addleshaw Goddard's Employment Channel on the 18th of August 2011. In today's programme, we look at a recent Employment Appeal Tribunal decision confirming an employee's termination date when they are dismissed during their notice period. We'll also look at whether a belief that the 9/11 and 7/7 terrorist attacks were part of a global conspiracy is capable of protection under discrimination law. And finally, we look at the government's recent steps to encourage more women in the boardroom. The recent Employment Appeal Tribunal case of M-Choice UK Limited and Alders is a useful decision which examines when an employee's contract of employment ends if they are summarily dismissed during their notice period. The tribunal sensibly held that the relevant date is the date the employee is summarily dismissed. This brought forward the effective date of termination and in this case had the effect of depriving the employee the right to bring a claim for so-called ordinary unfair dismissal as she didn't have 1 year's service. Here, Mrs Alders commenced employment on the 1st of February 2010. She was contractually entitled to 6 months' notice and on the 26th of July 2010 she was given notice to terminate on the 1st of February 2011. She brought a claim for unfair dismissal on the basis that she'd have the full year's qualifying service. On the 21st of January 2011 she was dismissed with immediate effect. She amended her claim form and argued that the principal reason for her dismissal was now because she had asserted a statutory right by bringing an unfair dismissal claim. The tribunal held that the summary dismissal didn't bring the effective date of termination forward and her claim was valid as she had a year's qualifying service. But M-Choice appealed and the EAT allowed the appeal. It substituted a finding that the effective date of termination was the date of her summary dismissal, and so she didn't have the necessary 1 year's qualifying period to bring a claim for so-called ordinary unfair dismissal. However, the key point here is that Miss Alders asserted the statutory right in her amended claim rather than a claim for ordinary unfair dismissal, and so the 1 year's qualifying service arguably doesn't apply. The case has been remitted to the tribunal to determine the reason for dismissal. Rebecca Ely, an employment law barrister at 9 St John Street Chambers, comments on what this case means for employers.
So, what can employers take from this case? The tribunal is going to look at the factual position to determine when the employment contract came to an end. The employer, having given an employee notice, is not prevented from summarily dismissing the employee during their notice period. But employers must be careful about their reasons for doing this. They may unwittingly give the employee a cast-iron claim for automatically unfair dismissal if the reason for the dismissal is an attempt to deprive the employee of their tribunal claim by ending service in less than 12 months. Such motivation can be characterised as dismissal because the employee has asserted a statutory right to claim unfair dismissal. This can be contrasted with other potential factual scenarios. Let's consider a hypothetical scenario. What happens, for example, if an employee has been dismissed on notice on grounds of capability? They are asked to work their notice, which will take them over the 1 year qualifying period. Within that notice period, and before the 1 year is up, the employee brings a claim for unfair dismissal in the same way Miss Alder did. The employer is aware of the tribunal claim, but then discovers that the employee is guilty of theft. The employer dismisses the employee summarily for gross misconduct, thereby depriving them of 1 year's service. Will the employee be able to bring a claim of unfair dismissal? Applying the principle in Alders, possibly not. As at the date the claim is presented, there is a valid claim, because the employee will have 1 year's service when the notice expires. However, the subsequent summary dismissal for theft overrides the dismissal with notice. Therefore, the effective date of termination is the date of the summary dismissal, which is before 1 year's service has accrued. Therefore, the ordinary unfair dismissal claim cannot proceed. Unlike in Alder, based on the limited facts given in the scenario, it is unlikely that an automatically unfair dismissal claim will succeed. Depending on the evidence and the findings of fact, the tribunal is likely to find that the reason for the dismissal is one of conduct, theft, potentially fair, and not the assertion of a statutory right, automatically unfair. So the claimant in this scenario will struggle to use the claim for automatic unfair dismissal to get around the requirement of 1 year's service in an ordinary unfair dismissal claim. Therefore, the reason for dismissal assumes central importance in such cases. If the summary dismissal is a response to a claim for unfair dismissal, it may give a claim for automatically unfair dismissal. But if there is genuinely a dismissal because of the theft, the employer is likely to be safe in respect of both ordinary and automatically unfair dismissal claims.
Thanks, Rebecca. We'll update you again when the tribunal decision about the reason for dismissal is available. The next case, although only a tribunal decision, is interesting as it represents the latest in the line of cases on religion and belief discrimination. It looks at the tests that apply as set out in the Granger and Nicholson case that we commented on in more detail in our news programme on the 14th of December 2010. And it's encouraging for employers who may feel that the floodgates are opening in terms of what constitutes a belief under the regulations. It's the case of Farrell and South Yorkshire Police Authority, and here the tribunal held that an employee's belief that the 9/11 and 7/7 attacks were part of a conspiracy by the global elite could not amount to a philosophical belief for religion or belief discrimination purposes. Mr. Farrell, a principal intelligence analyst for the police, produced a strategic threat assessment which included an explanation that, in his view, 9/11 and 7/7 were authorised by the US and UK governments to help persuade their populations to support foreign wars. He was dismissed as the police felt that his views were incompatible with his contract and prevented him from performing his role properly. Rebecca Ely again comments on the outcome in this case and what it means for employers.
The decision in Farrell, although first instance and technically non-binding, provides an interesting insight into the sorts of arguments which rage when determining the sorts of belief that can be given protection pursuant to anti-discrimination legislation. In order to come to a decision, the tribunal had to apply the guidance previously given by the Employment Appeal Tribunal in Granger plc and Nichols. So how did Mr. Farrell's belief fare against this checklist? The tribunal found that his belief was genuinely held, he held a belief rather than an opinion, the belief was relating to a weighty and substantial aspect of human life, perhaps not surprisingly. Although the beliefs might be shocking, there was nothing in them which was incompatible with human dignity. Where his belief fell down was on the issue of minimum standards of coherence and cohesion. The judge in this case commented that the claimant didn't have to show that his belief was right, but the tribunal was obliged to bring some measure of objective scrutiny to bear upon the beliefs advanced. The judge said the cogency requirement is harder to satisfy when the beliefs are about matters where there is a substantial amount of evidence in the public domain, as opposed to where beliefs relate to the unknowable, for example, the existence of a deity. The judge said the assessment must take into account the broadly accepted body of knowledge. When he tested Mr. Farrell's beliefs against that body of knowledge, he concluded that his conspiracy theories were wildly improbable. He noted that when the claimant was asked questions to test his beliefs, his answers were incoherent. What can we draw from this case? The decision highlights once again the distinction between the tests for religious beliefs and philosophical beliefs. It's evident that in order to keep some manageable limits on what constitutes a relevant philosophical belief, tribunals will test the evidence behind the belief in a way that they would not do where a religious belief was under consideration. It seems that religious beliefs, by their very nature, can be held in the absence of evidence, whereas philosophical beliefs must pass an evidence-based test. Even with a philosophical belief, it will, following the tribunal's logic, be easier to gain protection if it is the sort of belief about which there can be no evidence, or about which it is difficult to collate evidence. Whilst the tribunal said that the claimant did not have to show that his belief was right, in effect he was being asked to show that there was at least an arguable case that he was right. This will clearly not be the last case where tribunals are asked to address their minds to the concept of philosophical belief. Indeed, a first instance decision in the case of Kelly and others against Unison concerning apparently extreme Marxist Trotskyist political beliefs is due to be heard by the EAT this autumn, so watch this space.
Thanks, Rebecca. Finally, an interesting step has been taken by the government recently, which is very much a sign of the times. The Home Secretary and the Business Secretary have written a joint letter to all companies in the FTSE 350, urging them to increase female representation in senior positions to a minimum of 25% from 2015. Promoting gender equality on the board of listed companies has been on the agenda for the UK Government and European Union for some time, with the UK Corporate Governance Code last year being amended to include reference to the value of diversity in the boardroom. Various bodies, including the CBI, are keen for the code to be amended further as a matter of urgency to actively push for more diverse boardrooms. The Home Office is publicising the fact that companies with more women on their boards have been found to outperform their rivals, and since March this year, 31% of new board members were women. So things seem to be progressing slowly but surely. Of course, only time will tell whether the government is successful in achieving its stated aims. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.